communication and connection with debt collection. So A says communication with the consumer generally. So communication with you generally. Sometimes it makes it easier to read these laws when you just substitute things with phrases. So you know you're the consumer. So you can say, if your name is John, you could say communication with me or John generally. So without the prior consent, what does consent mean? You're allowing them. Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, a debt collector may not communicate with the consumer in connection with the collection of any debt. Just that section alone. We don't even got to go to, number 1, 2, and all that. You can quote 15 USC 1692 CA, communication with the consumer generally. They're not supposed to communicate with you. That's already a violation if they communicate with you. So that's $1,000 right there. All right, number 1, what does it say? At any unusual time or place, or a time or place known or which should be known to be inconvenient to the consumer. In the absence of knowledge of circumstances to the contrary, a debt collector shall assume that convenient time for communicating with the consumer is after 8 o'clock and before 9 o'clock, local time at the consumer's location. Let's break down that second sentence first before we get into the sauce of the first sentence. So it basically says a debt collector shall assume. Does an assumption mean it's correct? Just because a debt collector makes an assumption and then they call you, it doesn't mean they didn't violate you. What if they call you at a time that's inconvenient to you? That's a violation, 15 USC 1692 CA1. So the first sentence, it says at any unusual time or place, which should be known to be inconvenient to the consumer. So this is a sauce right here. What if, okay, let's say you're working your job, right? But what if you're also a business owner? As a business owner, let's say you work 24/7. So if a debt collector calls you, isn't that already a time that's inconvenient to you? I can't tell you what's inconvenient to you, but I can tell you what's inconvenient for me. Me as a business owner, I'm on the go 24/7. So if a debt collector calls me at all, that's inconvenient to me. That's already 15 USC 1692 CA1. That's a violation. That's $1,000. I'm gonna need that, right? So you got to really understand what's inconvenient to you. If you're a business owner, 24/7, you work. If you're at work and they call you, obviously that's a violation. The easiest way, obviously, is you working as a business owner 24/7. You don't even technically got to be a business owner. Maybe you're learning about business. You're still working, so that communication is a violation. Number 2, if the debt collector knows the consumer is represented by an attorney with respect to such a debt and has knowledge of such attorneys, etc., it's basically saying right there, which was in the previous section, if you have an attorney, they're not supposed to communicate with you. And earlier in the beginning, I was saying how some of these laws you're going to see are redundant, and it works in your favor, the fact that it is redundant. So in the previous section, 1692B, where we had the attorney law, that was a $1,000 violation. We can come back to 1692C, same violation, $2,000. We just double up, right? So just really understand that when you see something that's like repetitive or redundant, it's going to work in your favor. All right, so number 3. At the consumer's place of employment, if the debt collector knows or has reason to know that the consumer's employer prohibits the consumer from receiving such communication. What did I say about you as a business owner? I said, if you're a business owner, right, your place of employment can be literally anywhere. If I'm at the store or something and I'm a business owner, 24/7, I'm working. I might be buying some stuff for my business. You communicate with me, you call me, that's a violation of 15 USC 1692 CA3. So really just understand how it can work in your favor, right? Congress made these laws for you. It's up to you to utilize them the correct way. So communication with third parties, this is B. It basically is redundant again, based off of the previous section we talked about, so we're not gonna go over it. But 1692 CC, ceasing communication. This is where your cease and desist comes in. So if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer. You could just stop there. That's a violation. To such debt, except, so it says, number 1, to advise the consumer that the debt collector's further efforts are being terminated. So they can only communicate with you after you send a cease and desist notice to let you know that, okay, we're done communicating with you. They can't attempt to collect anymore. Number 2, to notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such a debt collector or creditor. So I wouldn't worry about 2 or 3 really, but the main one you want to worry about is 15 USC 1692 CC. So this seizing communication section. This is all I would really worry about as far as, getting your remedy and things like that. Remember, there's a lot of laws, there's a lot of sentences and things like that, but only get what you need, right? So if a consumer notifies a debt collector in writing, if you send a cease and desist notice, which we're going to go over, if you send a cease and desist notice that you refuse to pay that alleged debt, if it's alleged to you, it's alleged to me personally, to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt. So if you let them know, I refuse to pay this debt, they're not supposed to communicate with you anymore, right? And when you tell them you refuse to pay that debt, it's now been disputed. And we're gonna get into multiple debts, which is 1692H. I'm gonna tell y'all something y'all can do. We're gonna tie it to the Fair Credit Reporting Act. So yeah, just be taking your notes and then revisit it later. And if you bought the replay, watch the replay. If you didn't buy the replay initially, then you'll have a chance to buy it later. But yeah, that's the communication section. Any questions on the communication section? I'm gonna take some water and then just continue. All right. So 16